You've been hearing a lot about it, including on our air, a lot of commercials, pro and con. The scaffold law, and we were trying to dig into what it actually is and what it means and what the legal ramifications are. And here to help us get some clarification on that, our legal analyst, Chas Farcher from Martin, Harding & Mazzotti. Hey, Chas.
Hey, Chuck. How you doing? Good morning, Kelly.
Doing well, doing well. So the scaffold law, all right, I guess New York State's now the only one with it. And if I understand it correctly, basically it says that the contractor and the business owner, or the person having construction done, are responsible no matter what a worker does. Even if a worker is well-trained, and even if a worker shows up drunk or is just acting like a knucklehead and gets hurt on the job, it's not the worker's fault. Is that what the scaffold law is in New York?
No, and that's the problem. There's a lot of misinformation regarding the scaffold law. You know, essentially what it does is it puts the onus on the contractor or the construction job site to provide safety equipment. So if the contractor provides good working scaffolding, good working harnesses, and a worker decides not to use those pieces of equipment, or if the worker's own actions are the sole proximate cause of his injury, then no, there is no recovery, and that's something that's spread and put out there, and it's just not true. If a worker shows up drunk or high, and that's the cause of the injury, there is no recovery.
So then, what's the outrage over the scaffold law?
The outrage is that the construction companies are suffering from some sort of Stockholm syndrome, where they seem to identify with the insurance carriers who are holding them hostage with extremely high premiums. The problem is, and something we fought for in New York for quite some time, is for these insurance carriers to disclose what it is that their premiums are based upon. They argue that it's the scaffold law that's driving premiums up, yet they won't open their books or disclose any information or any proof that the scaffold law actually is any one of a number of driving forces that put the premiums where they are. We just don't know that, and they won't give us that information. They don't have to in New York.
So the issue really is with the insurance company. It's not with the law itself. It's with them driving up rates and not disclosing really why. They're just saying, hey, it's related to the scaffold law, but without saying exactly why.
It's the insurance carriers and insurance carrier lobbyists who tell construction companies that the reason their premiums are so high is because New York has this scaffolding law. But understand a couple things. One, New York is unlike most other states, especially with New York City. We have more high-rises, skyscrapers than any other state. This is not North Dakota or South Dakota, so we need that protection that other states don't have. Two, New York is not the only state with a law that protects workers. There are plenty of states out there. We may be the only state that has an absolute liability clause, but many, many other states have laws like this. States such as Ohio even make it criminal for certain job sites to not have these protections. And, most importantly, all the contractor or construction company needs to do to not be exposed to liability is provide the proper equipment. If it's out there and the workers know where it is, but they choose not to use it, there's no case.
So I'm just a little confused, though. What does the scaffold law do in New York that isn't done elsewhere? I mean, you're saying if a guy shows up drunk and falls, it's not the contractor's fault. If a worker doesn't use the harness that's provided, it's not. So what does the scaffold law do?
In most personal injury cases and in many other states, if you have a fall, there's comparative negligence. So if the worker is 10% at fault for his injury, he wouldn't recover 100% of his damages. He would recover 90%. New York's law takes that out. So if a worker shows up to a job site and the employer says, here's this metal ladder with improper feet on it, that's what you're going to use to hang siding today. And the employer says, well, I don't really want to use that, but I don't have a choice because that's all that's provided to me. Happens to have some marijuana in his system from that morning or the night before, gets on the ladder, and the ladder slips out on ice because it doesn't have the rubber feet like it's supposed to have. We're not going to look at that. We're not going to look at, did he have a little bit of marijuana or something in the system from 2 days ago? Is that what caused his accident? What caused his accident was not having the proper ladder. So there's no comparative negligence in New York State, and that's where you get the real big argument between insurance carriers and personal injury lawyers.
So, Chas, real quickly, aside from the contractor and their employees, if you're a business owner and you hire a private contractor to come out and do work on your building, and they put up scaffolding, they follow all the laws, somebody gets hurt, the contractor, the boss, is held liable, but is the business owner?
Generally, the person who's held liable is the contractor, the person who's controlling the job site. So, there's an exemption for single-family and two-family houses. So if you're a single-family homeowner, unless you're controlling the work, you don't have to worry about it. If you're a business owner, if you're hiring a contractor or a GC, the person who's controlling the site is the one that's generally held responsible.
Thanks, Chas. We appreciate the time.
Have a great day, guys.
We'll
Stay
talk
safe.
to you. Yeah, you too.